Good morning, everyone. Welcome again to the American Enterprise Institute. I'm Tom Miller. Our topic today is the dilemma that's facing the states in terms of their Medicaid programs, their Medicaid reform, in the wake of this Supreme Court decision, which may have opened up some new options, which were previously mandatory, if not compulsory, and perhaps rethinking some other alternatives. We want to extend the parameters beyond just the court case to what states have been doing with their Medicaid programs that might be an alternative pathway for reform, and how they might be dealing with this newer environment post-Supreme Court decision. We were planning to open with Secretary Gary Alexander of the Department of Public Welfare, State of Pennsylvania. It looks like he's been a little delayed in getting here from a meeting on the Hill. We also have Jim Blumstein, a longtime friend of AEI, who was instrumental in the way that Supreme Court decision came about, a professor at Vanderbilt Law School. Christie Herrera, formerly of ALLOT with the Foundation for getting my. That's all right. It's all right. It's a new spot. The Foundation for Government Accountability. We'll be talking about some interesting developments, particularly in Florida, but some other states as well. And we are expecting Congressman Bill Cassidy of Louisiana, who is also a physician, subject to, I guess, the House voting schedule, but he's supposed to be here about 11:30 to talk about his new Medicaid reform bill. So I called this a dilemma, and those of you who have ever studied classical philosophy and logic will understand the idea of the horns of a dilemma as to how to find a logical answer out of being confronted with a couple of choices which may not be the ones you want. The classic formulation of this is you either choose the horn on the left, and I think we know that probably means accepting the terms of the Affordable Care Act for expanded Medicaid, which looks like a lot of federal money, but has some other provisions attached to it which may not work out in the long run, and all that goes with the federal government to have an increasing role in running those Medicaid programs on a different basis than before. There's also the horn on the right you could take, which would, I suppose, in the most extreme version be to opt out of Medicaid entirely, or simply to say we're doing what we're doing right now and nothing else. But there are pressures on the states in terms of their budgets as to whether they will pass up the opportunity for someone else's seeming money, even though it came out of those state taxpayers as well, and what the other provisions are as well. The other part of normally dealing with this dilemma is, rather than taking the left horn or the right horn, is to say that there's not just those two choices, but you'll go between the horns. And so today we're probably looking to see whether you can go between those horns and find a different type of choice out there than either of the two I posed to you. If you've actually updated the classical version of the logical approach in the philosophical sense, there are some more modern versions. Back in the 1970s, if you're a fan of Zen and the Art of Motorcycle Maintenance, there were some other versions of this. One was, rather than take those three choices, to throw sand in the bullseye. And that's what both parties have mostly been doing, which is to basically do an ad hominem and attack either alternative and say they're all terrible and they're wrong, etc. And we've got a lot of that probably going on Capitol Hill today as well. There's another one, which is to sing the bull to sleep as opposed to making a choice, which is to say that even though you don't have the answer, somewhere out there in the magical, misty land, there is an answer somewhere. And we've had some of those propositions as well, whether it'll be the miracle of state innovation, markets will do it, or somehow what has never worked before through the government will work as well. That's kind of pretty much bypassing the issue. And then there is the final alternative, which is to refuse to enter the arena and fight the bull. And we've got some folks saying basically we're just staying away from this, we don't have any choice whatsoever, and it'll collapse of its own. So that's the logical and illogical horns of the dilemma. But before we engage this in terms of the substance and the practice of what might be some different settings on state-based Medicaid reform, we're going to begin with Jim Blumstein, professor of law at Vanderbilt Law School, also a longtime health law authority. We brought Jim in particular. He's been here before to talk about the Supreme Court decision, what went into it. Jim, behind the scenes and above ground, filed an amicus brief, really developed the core of the argument, which was reflected in the Chief Justice's opinion, that found for the first time he knew coercion when he saw it, and this was coercion and was way over the line and pointing a gun at the state states' heads. And then Jim, from his past experience, particularly dealing with the Tennessee program, TennCare, and other Medicaid variations, might give us at least a preliminary look at what might be possible or not possible or unknown under what seems to be a little different set of legal settings in light of the Supreme Court ruling. So we'll open up with Jim Blumstein. Jim?
Thank you. Appreciate it. Thank you for having me back, and it's good to be here. And I appreciate that Tom has given me a platform or forum to talk about the Affordable Care Act's Medicaid provisions. The Medicaid issue has been a sleeper issue. I've been a little bit like the Johnny Appleseed of the Medicaid issue. I've been pushing this on the lawyers for Florida and filed my own friend of the court brief, which, as Tom said, provided the analytical structure that the Chief Justice used for his opinion on the Medicaid question. And it was joined, I hasten to add, by there were 7 justices in the majority. Justices Breyer and Kagan specifically joined the Chief Justice's opinion in this regard. So this actually won, as I've said to Tom, because I'm not an activist, I'm an academic at heart, although I do get involved in the arena some. But from my perspective, I was a happy camper at the end when the court came out with its decision, and one of the few, I guess, because this was the first time that the Supreme Court has taken the language that promised that there were limits on federal spending conditions and actually created an enforceable set of rules in this regard. I want to cluster my talk around 3 things. I want to say a little bit about the original statute, how it was structured, the court decision and what went into it, and then a little bit about future challenges. And I think importantly, it's very important to get the right next case, because until you have a second case, if I remember right, you need two dots to draw a line, and one case is a dot. It's not a doctrine. So we need a second case to have a doctrine of some kind, and so it has to be carefully chosen and developed. So the key insight that I brought to the argument, or insights, were that the focus of the challenge should not be on coercion per se, but on the coercive conditions that inhered in the change in the terms of the Medicaid law, that there was a pre-existing Medicaid law. The Supreme Court for 30 years has analogized Medicaid and federal spending programs to a contract, and that this was an ongoing contract, a special kind of contract. And while it's okay to have foreseeable and modest changes within the original framework of a contract, what's called a relational contract has that. When you go unilaterally, go too far and have leveraging that's excessive leveraging, that the contract doctrine puts constraints upon that. And that's really what the court was saying here, is that it used the contract model developed from a case called the Pennhurst case in 1981, and that there are different doctrines associated with what a state can do when it enters the contract as opposed to when the contract is unilaterally modified, in this case by the federal government. And here, Chief Justice Roberts concluded that this was such a significant modification that it was in fact a new program, not foreseeable. The second point that I wanted to emphasize, and this gets lost in the discussion, is the Pennhurst case also established a requirement that there be notice, that states be informed of what they're getting in for. Are they in for a dime or are they in for a dollar? And that was something that has been in the law for 30 years. But what was new here was the question of the timing. When did the notice have to accrue? Did it have to accrue at the time of the state signed up for Medicaid, which is certainly implied in the Chief Justice's opinion? Or is it enough to have notice of the new terms and conditions and then link that to potential forfeiture of the pre-existing Medicaid? So those are the changes. That really is the doctrine that captured the 3 pivotal votes in the court in the Chief Justice's opinion. So let me talk about the Affordable Care Act and its structure. Half the new enrollees come from the individual mandate, and half are projected to come from expansion of Medicaid. Medicaid was designed to cover, the expansion action to cover all those with incomes under 133% of poverty, or with a 5% income disregard 138% of poverty. The ACA requires states to set up exchanges. If the states don't set up an exchange under 1311, there's a provision which I call the OOPS provision, which is Section 1321. Somebody showed Section 1311 to a constitutional lawyer and recognized that that's what the Supreme Court has called commandeering. The federal government cannot force the states to set up exchanges. It cannot command them to do that. They have to provide a fallback or an alternative, and that's what 1321 does. There was no attempt at putting that as a condition to spending. The drafters didn't even contemplate that, apparently. So the Supreme Court has held that while commandeering is inappropriate, you can't coerce states to act in certain ways. They can be induced, or in my more cynical ways, at times I say bribed. States can be induced to perform services, and the Congress and the federal government has the ability to use its spending power to induce behaviors that the Congress could not mandate on its own. But non-compliance, and that's the critical point here, with the expanded mandate, the 133% of poverty mandate, had consequences that were very significant. All of pre-existing Medicaid funding was put in jeopardy. If the states did not accept the new terms and conditions, this is what Chief Justice Roberts called the gun at the head. And the states were in a box, and I want to explain this politically and economically. Politically, the federal government, in effect, terminated traditional Medicaid. The states did not have the ability to stay in traditional Medicaid. It was the federal government that terminated traditional Medicaid and said the states could not keep the deal that they had had for 40 years. The states were obliged and given the opportunity to opt out of Medicaid, but this puts all the political onus upon the states. The headlines read, "States opt out of Medicaid." This is very difficult politically. This is political heartburn for the states, partly for political reasons, but also for policy reasons, that the most vulnerable people would not have health care coverage. But it really is not the states that are doing the acting. The precipitation of this is really the federal government. The federal government said, you can't keep the deal that you've had for 40 years. And so the headline should read, federal government terminates traditional Medicaid, states given the option to move into Medicaid 2.0 or new Medicaid. But that's not what it was. There's a big difference, and the Supreme Court recognized this in the public sector union case, the Knox versus SEIU case. There's a big difference between an opt-in regime and an opt-out regime. The states are allowed to opt out, but the opting out is very expensive politically, and it blurs the line of accountability that the court has often talked about, because it really is the federal government that precipitates this, not the states. Also, the federal subsidy on these exchanges only accrued to those with incomes in the 100 to 400% of poverty range. And that's really when I changed my mind about this law. It became pretty obvious that there's no rationale for not subsidizing those with incomes under 100% of poverty, except that nobody believed that the states could opt out as a practical political matter. And if the states did opt out, the most vulnerable people, the poorest and most vulnerable, would not be subsidized by the federal government at all. And the only rationale is that no one seriously thought that any state could opt out. And so this shows that there was some sense of coercion here. Now, economically, the states are in a pickle as well, because if the states don't act, they have economic catastrophe as a result of the Affordable Care Act, the Medicaid provisions. They have, and the Chief Justice Roberts recognized this, they have ongoing obligations to their Medicaid beneficiaries. Unless they change the law, they still have to provide coverage for their Medicaid beneficiaries. The federal government, however, will withdraw federal matching if the states do not accept the new terms and conditions. So this is the worst of all worlds, completely unforeseeable for the states, that they would have to, if they don't act, they would have to absorb 100% of the costs of Medicaid. 100% of the cost, not a proportion, but 100%, because they wouldn't qualify for federal matching, but they would still have an obligation. So they must act. and the notion of autonomy that the courts have put forward suggests that states don't have to opt into these programs, but here it's not a question of opting in. The states must act affirmatively in order to defend themselves. Finally, in terms of background, Medicaid started as a poverty medicine program. Medicaid was linked to welfare aid to families with dependent children, and later to the TANF program, Temporary Assistance for Needed Families. Medicare, which was enacted simultaneously, was linked to Social Security. So here we have medical coverage linked to income support programs, poverty for Medicaid and Social Security for Medicare. This goes well beyond any linkage to a pre-existing program, and I argued in the brief that there was no way that the states could foresee this type of expansion. Medicaid was in fact welfare medicine, and this is legislation as part of a comprehensive expansion of coverage to the non-poor. Now, the basic doctrine, let me spend a few minutes on this. Basically, when the federal government spends money, it can go beyond what it can do under its regulatory authority. And the Supreme Court, since the Penhurst case in 1981, has said that this is really like a contract. It's akin to a contract. And that states have sovereignty and certain autonomy interests, and that the states cannot be forced to participate in Medicaid. That's an important point. States cannot be forced to participate in Medicaid. If the states do participate, their participation must be knowing and voluntary. Now, how is this autonomy protected? It's protected in two different ways. One is through the requirement for notice, which I've mentioned, and the second is they're protected against overreaching or coercion by the federal government. Now, the clear notice rule was adopted in 1981, and it says that the federal government can only bind states if they give them clear notice of what they're in for when they sign up, when they voluntarily sign up for these programs. The issue in this case, and the one that I put on the table, is the timing of the notice. The federal government took the position that notice through the Affordable Care Act of the changes was enough. And my point was that if the states are really going to get good notice where they can decide whether to participate or not, whether to take the bitter with the sweet, they have to know what they're in for, and it's strategically the right time. And that's when they signed up for Medicaid in the first place. And so the perspective is that of the state government official. What would I do knowing the full facts? And if you're only informed of the changes, you can't be adequately informed at the front end. And the court, or at least the Chief Justice's opinion, adopted that notion. Okay, so advance notice is important, and states have to know the consequences. This is a way of protecting the state's decision-making process so that they can make a cost-benefit analysis to know what the bidder is, what the financial consequences are, as well as the sweet. Notice has a second role, what I call a negative role, and that is it protects against bait-and-switch tactics by the federal government. It protects against the states being told by the federal government, come in for a dime, and then after the fact say, well, you're in for $1. And that those conditions were unforeseeable, and the notice requirement protects, and the Chief Justice mentioned this at least twice in his opinion, that the federal government cannot, after the fact, blindside the states by these bait-and-switch tactics. And so the notice is important there. And so the key question is, when does the notice apply? And while the Chief Justice's opinion is somewhat ambiguous about it, it seems pretty clear to me, based upon the analysis in his opinion, that he was saying that the fair notice had to have occurred when states opted into Medicaid. And if the federal government wants to add these conditions that are substantial changes that were not foreseeable, they have to give you notice at that point, but they can't link the two to each other. If the federal government wants to terminate Medicaid, it can do that, but then it has to reenact it, and as the Chief Justice in a footnote says, you have to put all the issues at risk on the table. So yes, the federal government can terminate Medicaid, but it has to take the political responsibility for doing it, and the advocates for Medicaid have to put it up for reenactment and for possible change. The notice timing issue had not been discussed before, and I think it carried the day in this case. It's an easy way for the court to rule. It did rule this way, and I think it's very important. The second part, the coercion part, is it has long been a limitation on federal spending that the states can be induced but not coerced. Is this judicially enforceable? The federal government said the standards are not good. Justice Ginsburg in her dissent said, how do we know what coercion is? And so she argued that this was not judicially enforceable. Another important part of what the Chief Justice held in this case is that the coercion limitation, it protects state autonomy interests, state sovereignty interests. And just as the court has said that the federal government cannot force in a formal way states to implement federal law, they cannot in a functional way coerce the states to act. And so the Chief Justice very clearly said, citing this Pennhurst case, that the legitimacy of federal spending depends upon non-coercion, that states have a real choice, in fact, not just in theory. And if you want to think about this, and I'll kind of move toward the conclusion here, think of the Alaska Packers case. You had sailors signed up for a contract, had a certain wage. They went out onto the ocean. They got to the fishing waters, and they told the boat owner, we're not going to fish unless you double our wage. And the boat owner said, look, we don't have a choice. This is excessive leveraging. It's coercion. And because you've changed the terms of the deal. And in my view, that's really what the federal government did with the Affordable Care Act. It was really like what those sailors did to the owner of the boat. And the court in that case said it's fine to negotiate wages and so forth, but you have to do it before the ship sets sail. And that's the point here, is that the federal government can terminate Medicaid, but it then has to recreate Medicaid 2.0, take the heat for terminating Medicaid, put the issue on the table politically, and give the states the notice, and then let the states decide whether they want to sign up or not sign up without adverse consequences from inaction at that point. So the other themes here are that with the subsidy strategy, clearly it was designed to coerce or to force the states to participate. As I said, that's when I changed my mind about this. There's an issue of the magnitude. This is a huge program. It far outstrips any other federal program, and on average constitutes over 20% of state budgets. In Tennessee, it's over 25%. The states have a reliance interest here. They've developed state administrative infrastructure. They've developed medical infrastructure. We have hospitals, doctors, nurses, other providers that have invested based upon that. State inaction breeds disaster, and basically if you're going to protect states, that really means protecting states if they don't act. And if they don't act here, it's a catastrophe. So the sheer size was important, but the structure was important as well. All right, so where does that leave us going forward? I think we have to be careful, if you're looking at this from the state perspective, not to just say, well, this is hard on us, there's a new term or an expensive condition, we don't like it. If it's in the initial grant, I would urge states not to challenge that. The critical point here is that there was a program, it was an ongoing program, and then there was an unforeseeable major change that had substantial fiscal implications. That's the kind of thing that can be subject to challenge. If there's something that was part of the original program, or if it was implicit, the Supreme Court has said that implied terms in the original contract will be upheld. Here, we were able to make the case that the coverage of folks under 133% of poverty, well beyond the original contours of Medicaid, were not foreseeable. States could not have anticipated this extra obligation. So it's very important to pick and choose the areas. There was an accountability concern that the federal government had terminated the pre-existing Medicaid program. It didn't call it termination, but in fact it was, because the states had no choice. They couldn't remain in Medicaid. And then ultimately, the spending power does have limitations. There are not unfettered conditions. And so, but what is that limitation? I would say, again, it's not just the sheer magnitude. We're not going to have anything like Medicaid. If we're going to have a next follow-on case, it has to be something where the states were blindsided, where they didn't have notice, they couldn't foresee, and it was a big change with great expense. So I think that's really the strategy into the future, Tom. what the kind of the description of what the next challenge should be without naming the program. Thank you.
All right. We're going to go to Secretary Alexander in just a couple of minutes, but as we do in law school, you have to answer a few more of the hypotheticals, Jim. That's the case we had, which was the clearly teed up one. You may have dodged the issue, but I'll go ahead and ask this. We've got some other provisions in the law, most notably maintenance of effort. One would argue, and certainly some states are starting to move in this direction, they didn't get anything in return for this maintenance of effort. It's not like the stimulus law, where they were getting extra money and they agreed to the extra money in return for doing that. Now, there is certainly a range at which the HHS and the Center for Medicare and Medicaid Services can impose additional rules. It's within the zone of updating a program. So is there a challenge under this type of coercion doctrine to say, just a minute, you can't lock us in to our programs if before you locked us in unilaterally in this law, we used to be able to change our eligibility if it wasn't mandatory coverage. Right. And the other part of this is, although it's a little fuzzy as to how you want to interpret it, there's another provision that says basically until the states have up and running an eligible, certified, state-run exchange, that maintenance of effort. I didn't even see a termination date on that one, although I think there may be implied that basically they're locked into that old program until they play ball, even if there's a federal exchange. Is there a range of at least probing on that front to see how far coercion goes?
Yeah, the maintenance effort issue is one that attracted my attention early on, and it really depends on how, as you look at the history, how strong a case the states can make that they did not have reasonable notice that this was the type of term and condition that was not to be imposed. The problem is that the federal government has, in fact, raised the floor. I mean, Medicaid has a floor and a ceiling, and the history has been to raise the floor. And but whether they can foreclose all state flexibility or not depends a little on what was foreseeable. What was the landscape when the states got into Medicaid? I think that the Chief Justice's opinion talks about flexibility. I argued about the importance of flexibility within a cooperative federalism framework. I think that that's a close call, and I would certainly want to make sure that the expenditures were high, that the limitations are substantial. To the extent that it's short term, like 2 years on transitional, I think the federal government has a stronger case to be made. If it's permanent, that we never foresaw that we'd be locked in forever to this, I think that's a stronger case. And so I think one of those maintenance of efforts provisions lapses in a couple of years. I wouldn't necessarily want to litigate that because it's going to self-destruct. If there's something that's more permanent that says after the fact we've locked you into something that you didn't foresee, I think that's a much stronger case for challenge. And certainly linking it to the exchanges is troubling because the federal government cannot force the states to establish the exchange. And this looks like the linkage that the Chief Justice was talking about, and I think that would be a better challenge. But again, I'm going to take an agnostic position until I think about it in more detail. Tom has been peppering me on that, and I've given it more thought, but I'm not ready to declare my position on that.
Well, maybe you can put a gun to their heads as long as you're firing blanks.
No, they rejected that position. There's a footnote on that very point.
Okay. All right, our next speaker, he was unfortunately delayed by a meeting this morning on the Hill, and he's going to be going back to another meeting on the Hill after he's through speaking here, is Gary Alexander, who is well known to the folks in the field as an expert on health care, Medicaid, welfare reform. Most recently, he was appointed to be the Secretary of Public Welfare for the state of Pennsylvania in January of 2011 in the Tom Corbett administration, where he's responsible for overall management and policy development of. Now, this is described as the largest state-level health and human services agency in the nation. I'm not sure if that's considered a positive or a negative, but in any case, he's got a lot to handle in Pennsylvania, and working perhaps to downsize the scope and size of his clientele over time, admittedly in these troubled economic times. Before that, Gary was in a similar capacity as Rhode Island's Secretary of Health and Human Services and Human Services Director for about 5 years, from 2006 to 2011, and that's where many of you may have first known of his work in putting together, as an architect and author, the 2009 Rhode Island Global Medicaid Medicaid waiver, which offered a whole new range of possibilities with the federal-state agreement for providing greater flexibility at the state management level in return for some accountability on what they could produce. And we've heard the early returns, and they sound pretty good on that. So Gary's going to talk today both about what he's done in the past, what he's doing currently in Pennsylvania, and what we need to do in the future. It's a pretty big mission to fulfill. Gary
you.
Alexander.
Thank you so much. I appreciate being here. This is really an honor to be here. And I did enjoy what you just said. I'd like to get a copy of some of what you've just said, so it was very, very interesting. As you know, we struggle with the Affordable Care Act or the President's Health Law, and when you talk about maintenance of effort, some of the things, the small things that we at the state level struggle with, for example, we currently have millionaires or on the Medicaid rolls. We've got lottery winners, and when we want to eliminate that category, it violates maintenance of effort. So the maintenance of effort provision really is dysfunctional simply because it locks states in. For example, in Medicaid law, states are allowed or have the possibility of imposing a work requirement in Medicaid. We cannot do that because of the maintenance of effort requirements. So there's certain issues around that, and they provide a host of challenges for states. I'm a little bit dysfunctional when it comes to technology. What is the welfare problem in this country? I think, as everybody knows, there is chaos in the system simply because of the many programs, federal and state programs and local programs that do not comport with one another and that cross over and create really a myriad of challenges for state administrators and for the recipients that receive the services. And the president's health care tax makes each of these problems much worse. What I do want to say about Medicaid is, which is the largest welfare program, it does have a clear purpose intent, and I think many of us forget this, that according to the law, Medicaid is to furnish rehabilitation and other services to help families and individuals attain or retain capability for independence or self-care, and that's been repeated in Supreme Court cases. It's very important that we remember that because the original intent of the law, as was just stated earlier, was that Medicaid was for poorer people and also for the purposes of moving them out of poverty. I don't think anyone who envisioned these programs ever envisioned anybody staying in these programs indefinitely. I wanted everybody to see a definition of the welfare system that comes from, it's not Republican, not Democrat, it's from an encyclopedia on economics, that the United States welfare system would be an unlikely model for anyone designing a welfare system from scratch. The dozens of programs that make up the system have different and sometimes competing goals, inconsistent rules, and overlapping groups of beneficiaries. And I will tell you this, that most states do not have an unduplicated count of our own caseloads. So, for example, if you call a state and ask them how many people on their caseload, they can tell you how many on Medicaid, they can tell you how many on food stamps. But if you ask them for an unduplicated count, you're probably not going to get it. This is the agency that I run in Harrisburg. And yes, it is the largest health and human services agency in the country, and it is because larger states such as Florida, Texas, New York are county-based. In Pennsylvania, we run everything out of Harrisburg, so we've got 17,000 employees, close to a $30 billion budget. And this is what it looks like if you work in our department. These are all the federal agencies that we have to deal with on a day-to-day basis, and this is what happens to our department with all the conflicting rules and regulations that we get. Even the Department of Justice touches public welfare and health and human services, as you know. So many, many, many agencies touching us, including education, which does not comport with Medicaid, as we know. What I want everybody to see is many times we hear that the care for Medicaid clients is not good, and maybe in some states that may be the case, but in the states that I've worked in, and especially in the Northeast, we generally pay for the costliest care. So, for example, in the city of Philadelphia for outpatient services, let's just take a colonoscopy, for example. A colonoscopy at one hospital will cost $3,000. At a competing hospital, it may be $1,500. At a surgery center down the street, it'll be $800. Same quality. In fact, at the surgery center, generally the quality is better, morbidity rates are better. And if you'll guess where more of the clients go to, they go to the higher cost setting. They'll go to the hospital, the $3,000 hospital, and it is costing the Medicaid program billions of dollars every year. In fact, in Pennsylvania, I think we could save, probably over $1 billion just by directing patients to lower cost, high quality. I want to repeat that: lower cost, high quality settings. What happens with all this chaos? What happens to the recipients on welfare? It's very important that we focus on the individuals. They're needy. They need to move out of poverty. We want to see them move out of poverty to attain the American dream. The current state, welfare state, whether it's Medicaid or any of the programs, is failing to do the job. Instead of helping people, it's trapping them in a life of dependency. Welfare is supposed to be a safety net and not a trap. And one reason I know it's failing is because I have people who have been on, for example, TANF, which is supposed to have a 5-year time limit, for more than 14 years now, some of them close to 20 years. And some of these people are disabled, but many are not. And I'd like to talk to you about why that's happening. And let's take a look at a typical welfare family, one mom and 2 kids. And you'll see this is, if you look at the red line is income without taxes, and with taxes you'll see the curve, and as your income goes up you pay more in taxes. To understand the problem, it's best to look at the family's income continuum. So this chart depicts the family's income on a sliding scale. You can see that a family making $60,000 takes home about $49,000. This is called the welfare cliff. This is what happens to a family, a typical family in Pennsylvania. You'll have the single mom on the program will be better off earning a gross income of $29,000 with $57,000 plus in net benefits in income than to earn a gross income of $69,000 in the private sector with a net income and benefits of $57,000, because she'll be paying much more in taxes. So if we stack on welfare benefits, you can quickly see what happens. The welfare cliff crops up in several spots. The family is trapped. As the mom looks over the horizon, she realizes she must find a job worth $69,000 in order to maintain her current quality of life. Taking a job that makes less than $69,000 will actually hurt her family. So aside from trapping people on the cliff, the system has other problems. The system is inequitable. People earning more gross income end up with less than those who are subsidizing with their taxes, and consequently it discourages work not only for those in the system, but also those just above the system. What's the result is out of control spending. You'll see in Pennsylvania, adjusted for inflation, you're going to see the growth in our Pennsylvania welfare budget, which of course includes Medicaid, over the past 10 years, adjusted for inflation, like I say, has grown at 36.5%. Without adjustment for inflation, it's well over 100%. But as you see, the poverty rate is below the growth in the program. And if you look at general fund revenues, they've only grown at about 1.3%. Now, this is going to compound every 10 years. Revenues are just not growing at the pace of the department, and it's creating a huge fiscal cliff for all of us. These are national Medicaid expenditures, and as you see, the official forecast of the United States Department of Health and Human Services, we're on that upward trend that's very, very high. If you look at enrollment growth, that continues to go up. Growth in medical assistance enrollment since 1979 in Pennsylvania. The population in Pennsylvania has only grown at 7.2%. The Medicaid enrollment is up over 100% in the last 30 plus years. So it's creating a huge problem. There have been Medicaid expansions over those years, but not enough to comport with that 7.2% population growth. In other words, even if you strip out the expansions in Medicaid, it still far exceeds the population growth. So more and more people are coming on to public programs that were never designed for this many people. As you see here, this chart depicts the dramatic difference in the accumulative growth between food stamps, now called SNAP, and Medicaid since 2001. Over the 10-year period, food stamp enrollment has increased 158%, and Medicaid enrollment by 52%. Government employment has grown 6%, but private employment declined 2.5% over that period of time. And Pennsylvania just instituted an asset test in the food stamp program because we found that we had many people with assets, an abundance of assets coming on to public programs. And these programs were designed as a last resort. They weren't designed so that myself could come down to a welfare office with, say, $60,000, $70,000, $80,000 in the bank, lose my job, and start using food stamps while I preserve all of my benefits. These programs were designed so that when I exhausted my income and I was destitute and I needed help, I would come to the government. That's why we instituted or started these programs. This is very troubling. In 1966, we had close to 18 workers working to support one person on Medicaid. Today, we have 2.5 workers for one person on Medicaid. And if you take out the government employment in this picture, we're down to 1.9 workers in the private sector to one person recipient on Medicaid. It's clearly unsustainable, and we need to take a look at this. And it's by adding people, giving them an access card, it's not going to change the dynamic for healthcare. And that's why I showed you earlier that slide on transparency in healthcare and why that's so important and why we need to direct people to low-cost, high-quality settings. This is 2011 national data. In 2001, over 3 people in the private sector supported one person on Medicaid. Right now, we have, for every 1.65 employed person in the private sector, we have one person receiving public welfare assistance in the United States. For every 1.25 employed person in the private sector, one person receives welfare assistance or works for the government. Clearly, it's the average hardworking taxpayer out there right now working for, it's the makers versus the takers situation, and we need to change that dynamic if we're going to have a safety net for the truly vulnerable, for the disabled people that we need to serve, and for those truly destitute seniors, not those seniors that are middle income or upper income that transfer their assets. Disability. As you know, as a kid growing up, I had disabled people in my family, quadriplegic, and we all know how difficult that is, and we have compassion on those people, and they need SSI. And if you look, the only time that the SSI program actually had a lid on it was during the Reagan administration. After that, it has grown dramatically, and a record 5.4 million workers and their dependents have signed up to collect federal disability checks since President Obama has taken office. We've started to really look at the definition of Social Security, and something was built into the law recently called functional equivalence, which workers are now using instead of the strict definition of the Social Security law. This is very damaging, and it's especially damaging for children because we have more and more children on this country accessing SSI. And as you know, when a child gets on SSI, they never work, because as they hit their teenage years, they can't go to work and receive an income and still receive their check. So that stigma stays with them forever. And this is something if we care about kids, we have to really take a look at. State-based solutions, the Rhode Island solution. In 2007, late 2007, Rhode Island approached the federal government for a block grant with risk share. We were denied that simply because it was a Democratic Congress and you needed an act of Congress. We settled on a capped allotment of funds. over a 5-year period of time in exchange for real flexibility in the program, waiving freedom of choice, any willing provider, all of those onerous federal rules that states have to deal with that limit us in our capacity to innovate as a state. And the state set out on this new waiver, which is the closest mechanism we've had to a block grant in the Medicaid system to date. And after 2 years, Rhode Island has stayed $1.7 billion under the federal state cap of $12.07 billion. The state has also saved over $120 million in combined funds through a myriad of savings initiatives. But what's most amazing about the flexibility that the state received is the culture change that comes when you have a block grant or something similar, because state bureaucrats now are forced to have to innovate and look to really change the system. Unfortunately, one of the biggest reforms in the system, which the state was granted to be able to do an HSA-type account for the entire population, was revoked by the new administration when they came in. Having one waiver with a spending cap set below historical patterns in accordance with federal government allowed Rhode Island to break down silos of care in services. And you know, before our global waiver in Rhode Island, if the state spent $1 it can't afford, the federal government is happy to match it with dollars they don't have. And the Rhode Island waiver changed those incentives. You'll see where we're at now in Rhode Island. I'm not there anymore, but Medicaid and cash assistance programs in Rhode Island were projected this year to run a $30 million surplus. And for a small state, just to give you some context, to put that in Pennsylvania terms, that would be about me doing that in Pennsylvania would be about $400 million surplus, which would pretty much solve our budget deficits. And what are the results? In 2011, the Lewin Group performed an independent study, and they found that the Ocean States reforms with a federal waiver had been highly effective in controlling Medicaid costs and improving access to more appropriate services. And let me tell you that when we were trying to do this waiver, all of the pundits were saying this is risky for Medicaid clients. We were going to push Medicaid clients down the stairs, elderly Medicaid clients in a wheelchair. They had the governor, in a cartoon in the newspaper doing this. All of the Washington pundits were saying it's risky to put a cap on Medicaid because of unemployment. Rhode Island's unemployment rate is 11%, one of the highest in the country. This is still being achieved. Savings still being achieved. And they're still well under the cap that the federal government gave them. Solutions moving forward. Harnessing the laboratories of democracy, maximizing flexibility to the states, and looking at specific reforms. We all know about TANF. TANF was a mild reform, I believe, in this country. I never thought it was a major victory, simply because by not including all of the programs in a block grant structure, individuals were able to find other means outside of TANF. Be it as it may, though, TANF is a good example of a victory in that respect. Innovation and creativity by the states will produce savings with freedom from federal rules. An initial 10% savings is very possible. We in Pennsylvania have run several financial models on potential reforms for Medicaid and estimate total savings between 7 and 16%. The federal government can attain, as you know, the super committee had a goal of about $1.5 trillion in savings. Had they had put Medicare aside and Social Security aside for another day and just looked at means-tested welfare programs, we had estimated that just looking at Medicaid, they could have saved, if you look at this chart, by just a modest decrease in Medicaid spending of little over 1%. The super committee could have saved $1.5 trillion over 10 years in federal savings and close to $2.5 trillion combined state and federal. If you look at the capped growth, if we just capped Medicaid growth at 4%, and as you know, I don't know how many of you in this room receive a 4% raise every year, year over year. I certainly have, and most people in the private sector definitely don't. They usually get a decrease in salary. If we increased Medicaid spending by 4% year over year, the federal government would still save $771 billion over 10 years, and a combined savings with the states of close to $1.3 trillion. So it can be done. Lastly, what are the three things that I think we can do right now? And in this environment, I would encourage Congress, and I would encourage everybody, that we can do things with waivers, understanding that there is gridlock on Capitol Hill, and it would be difficult to change Medicaid law. But we do have the possibility of the Medicaid waiver system. Rhode Island is an example. If all states were able to get a Medicaid-style waiver like Rhode Island did, if you extrapolate Rhode Island's savings across the country, and Rhode Island is a very blue state, we would be able to save a combined federal-state savings of about $1.8 trillion over 10 years. That's very, very significant. And I would encourage, both the president and Governor Romney to really look at the waiver system, giving states flexibility right now, because you don't need an act of Congress to be able to give a state of the flexibility that another state has already achieved, and Rhode Island already has that waiver. Of course, lastly, I think the only way to really reform the system is to give a mega grant or a mega block grant of all means-tested public welfare programs, including housing, to states. And if we did that, we in Pennsylvania estimate that we could save approximately $129 billion over 10 years, and if you extrapolate that over the country, it's close to $3.2 trillion of total savings in state and federal money. This can be done. It can be done without harming individuals. In fact, it can be done with work requirements, by creating independence accounts to move people off of the welfare, public welfare and Medicaid programs into the economy. It can be done without hurting anybody, and still serving the populations, the neediest populations that we have, not the expansions to try and move Medicaid into, middle-income America or subsidies, but with the current populations we have, and we can do this in a way that makes sense and solves our fiscal dilemma, but also solves the more important dilemma of helping people out of poverty, which is our real goal. So I thank you very much.
Thank you. My microphone's been cut off. Take that one for a second, at least I'm not getting the button. I'm out of power, just like many Pepco customers these days. And there wasn't even a tree overhead. Gary talked about you can't change the law. Actually, our next speaker is trying to change the law, and we'll get to him in just a moment. Congressman Bill Cassidy has joined us. Secretary Alexander has to leave, I think, around noontime, so let me just ask a question or two follow-up. Two parts. One is, in a larger context, you've done a lot of work with the Republican governors, so this is not just a single state initiative. If you could give us a sense as to what might be a broader front. I know we saw yesterday a letter from Governor McDonnell on behalf of the Republican governors indicating, tell us a little bit more about exactly what are the parameters of this post-Supreme Court Medicaid decision. And I guess the other part of this is, do you see some opportunities for perhaps some increased bargaining leverage for states who'd say, I'm not participating in what you've planned, but let's talk about what we might do along the lines of a waiver, because we're not automatically locked into what's laid out on the menu in the Affordable Care Act?
I certainly think that the governors right now, a lot of governors are coming out with repeal, and they don't want to participate. Some states are waiting, like Pennsylvania. We're one state that's looking at our data currently to see where we're going to go. But clearly, the Republican governors are looking for flexibility, and I think they've said that over and over again, that states need flexibility to be able to operate. I'll just tell you quickly, in Pennsylvania, we spend about $3 million in state-only funds, $2.5 million state-only funds for health care and welfare programs. We just block granted that down to our counties. We have 67 counties. We received bipartisan support, no inflator. In fact, a 10% decrease, and we received bipartisan support from Democrats and Republicans at the local level for flexibility. So administrators know at the state and local level that we need flexibility. We need We need portability. We need flexibility. The governors are talking about trying to incorporate a work requirement. But you asked about the opportunities. I think that if a state were to say yes to doing some expansion, I think they would look for concessions to impose real work requirements around those that can go to work, and to have limitations on their health care, greater cost sharing, more personal responsibility, more premium assistance and really an MOE requirement on the individual. We talk about MOE requirements on the states. For able-bodied individuals, and we've got millions and millions on the program, we need a maintenance of effort, each one of them, and that maintenance of efforts should be to improve their own health care and to get a job and to move into the workforce. And for those who say there aren't jobs out there, there are a lot of entry-level jobs out there. Every time I go into a Target, or I go into a dollar store or anywhere like that, they're always hiring. We have to start somewhere. I know it's not the $40,000 or $50,000 a year job, but people have to start somewhere. In fact, and I'll just say briefly, we have a number of people who have come onto the system because of the economy, and they were mid-level managers and workers, and they will not take even an entry or a job at a Walgreens, for example. They'll come on to Medicaid and food stamps, but they won't go down and get on a management track at a Walgreens or a CVS or something like that because they're trying to wait for a better job. We have to have those requirements in place to say, if you want some assistance, you've got to get back to work. So I think that's where the opportunities.
Thank you very much. Our next speaker is Congressman Bill Cassidy. He's a representative for Louisiana's 6th Congressional District, first elected in 2008. He previously was an associate professor of medicine at Louisiana State University, and he's not just talked about health care in the abstract. He's provided care for uninsured patients and taught doctors in training at Earl Long Hospital in Baton Rouge for the last 20 years. He also co-founded the Greater Baton Rouge Community Clinic, which provides free dental and health care to the working uninsured. Currently serving on the Energy and Commerce Committee, on its subcommittee on health, commerce, manufacturing and trade, and environment and the economy. And I guess you'll be repealing once again shortly later today on the House floor with a vote scheduled. He's also, we've talked a lot about state reform. There's also reform of federal law. And just recently, last month, he introduced his bill, the Medicaid Accountability and Care Act, which has a different approach to beginning to make some sense of Medicaid policy at the federal and state levels. Congressman Bill Cassidy.
Thank you, Tom. Again, my bio, if you will, is I've been working in a public safety net hospital for the last 20 years. And I couldn't help but notice that whenever politicians expanded Medicaid, the state would just say take the same amount of dollars that it had and spread them more thinly. And on paper, it appeared as if there was increased coverage, but in reality, in my safety net hospital, the lines got longer. Because the Medicaid program paid private providers so much below cost, they no longer had access and instead were forming queues at my hospital for the uninsured. So as we speak of the current Medicaid system, one, we know that it's bankrupting states and federal budgets, crowding out spending for everything else. I think last year, for the first time, most states spent more on Medicaid than they do on education. It is the illusion of access without the power of care. It appears as if we're doing something. Politicians cut the ribbon, slap themselves on the back, and my lines grow longer at my safety net hospital. Unfortunately, it is associated with poor quality outcomes. I'm a practicing physician. This matters tremendously to me. University of Virginia peer-reviewed meta-analysis found that those on Medicaid had worse outcomes than the privately insured, Medicare, as well as the uninsured. And lastly, and something that may have, I think it was Bob Moffett that first did this. Was he at AEI then? But Bob Moffett first brought to my attention, so I just want to give him a shout out. There's a huge payment disparity between states per individual. I have a slide on that in just a bit. So in our Medicaid Accountability and Care Act, we actually take something which was proposed by Santorum and Graham in the 90s from the right, and the Clinton administration from the left. the way we take this is you break down, we know that Medicaid is actually 4 different programs, right? It is children, it is adults, principally pregnant women, it is the elderly long-term care, and it is the blind and disabled, with very different cost structures for each. So for a pregnant woman, maybe $2,500 a year. A child may be $1,250. For a person in a nursing home, maybe $60,000 to $90,000 a year, and blind and disabled even more. Yet we lump them together now and present the bill to the federal government. The idea is that you would break these out into 4 categories. And we do a per enrollee payment per category. Now, last bullet point, I think one of the strengths of this proposal is it strengthens the counter-cyclical nature of Medicaid. If you have a block grant, and your block grant amount started in 2007, when the economy is humming and you've expanded your benefits and raised your provider rates, the recession hits and your enrollment increases by 5 to 10%, and yet your amount of block grant grows only by 3% or whatever the inflator is. The state has, I think, insufficient ability to meet the demands of increased enrollment. So making it a per enrollee payment, oh, listen, we've got 5% more children, we've got 10% more adults, actually increases the countercyclical approach, which is a goal of many. The other thing is, theoretically, and this I think is the moral case, theoretically, Medicaid is supposed to equalize, and the federal matching assistance program is supposed to equalize the amount of money spent per poor person, no matter where they live. Mississippi is a poor state, so they get a higher FMAP. New York is a rich state, so they get a lower FMAP. Each puts up a certain amount of money. At the end of the day, the poor person is supposed to have roughly equivalent amount of support. Now, as it turns out, there's no correlation between the state's poverty level and federal payments. Bob Moffett, in what he wrote as a dissenting opinion on a Medicaid report, mentioned how Mississippi would receive $2,500 federal dollars per recipient, and New York received $7,500 per Medicaid recipient. Now, clearly, it costs more to care for someone in Manhattan than in Meridian, Mississippi. On the other hand, is it treble? So we put up this slide showing the federal Medicaid payment per category. So again, we're 4 categories: children, adults, disabled, and aged. Here is New York right here. You can contrast it to my state. Here in New York, per aged, they would get federal Medicaid payments roughly $14K per year. And then Louisiana would receive 62 or something like that, 65. Now you could say, well, wait a second, Louisiana's a poor state. Contrast it with California. California, not much difference between cost of care in San Francisco versus Manhattan. And you can still see that California does very poorly in this. In the disabled category, you see a similar discrepancy. And although the relative amounts are less different between adults and children between each state, when you'll notice here the amounts are actually a little different. In New York, they receive less than Texas from the federal government for expenditure upon adults and in children. That said, these numbers, because it's so much larger of a population, actually means more in absolute dollars. So let me go back up. So the MAC Act over 10 years attempts to address that, saying that if we have an outlier here and an outlier that's low, over 10 years, we're going to bring these, gradually glide path them in to where every state for each category, children, adults, long-term care, blind and disabled, each glide paths in so it'll be a mean of federal contribution of 100 plus or minus 10%. Somewhere between 90 and 110%, each state will fall within that category. Now, as we saw, in adult care, New York may move up. In long-term care, it may move down. California looks like it's going to be a winner across the board. And I can go on with that. But the idea is that if we, as a purveyor of federal tax dollars, we would not allow there to be this huge discrepancy between each state. By the way, we have somebody from Pennsylvania here. Let me point out one more thing that I don't have a PowerPoint on. Although I favor block grants over the status quo, a problem with a block grant, if it's not negotiated individually, is it makes no accounting for differences in state demographics. So Florida, Pennsylvania, and Vermont are three of the oldest states in the nation in terms of elderly population on Medicaid. Utah is one of the youngest. If you give a standard amount of money per Medicaid recipient, Utah is going to do great, because really those children cost so little. But if your payment is based upon a mean of total Medicaid expenditures, Utah is going to do really well. Pennsylvania, Vermont will do poorly, because they are top heavy in these costly, aged, and disabled categories, whereas Utah is top heavy, if you will, in these two categories. So just taking a mean payment does not work. You really do need to break this down into categories of recipients. We also set up a dual eligible option. I thought about that Virginia paper. Why would they find that hospitalized Medicaid patients do worse than the uninsured? Now, the case mix adjust, but still, and it's different from the Oregon paper, which found that once you get Medicaid, you do better. Whatever the criticism of the Oregon paper, that's its findings. The Oregon paper was principally outpatient. The Virginia was inpatient. If you assume that dual eligibles, 5% of the population, 50% of the cost, or something such as that, are receiving Medicare and Medicaid payments, which often work at cross purposes, because the incentives to maximize here actually defeat patient care there and vice versa, you understand why hospitalized dual eligibles do poorly. Disaggregated payment creates disaggregated care, which leads to poor outcomes. So the idea is we would give the states the option to have the actuarially defined amount of Medicare payment for a dual eligible, and then they could coordinate that care, that payment and that care, which would align incentives, which would improve patient outcomes, and ultimately save tax dollars. We also change financing. States are struggling to meet their state match. And in turn, they have sought this, they have used this as an excuse to use financing schemes, which many people, including the GAOs, Simpson Bowles, and others, have criticized. These include intergovernmental transfers, certified public expenditures, etc. So what MAC Act does is it lowers everybody's state match to the same, which is the lowest current state match, which is that of Mississippi, roughly 23%. New York goes to 23%. California, all the 50% states go to 23%. But in return, you can no longer use intergovernmental transfer, certified public expenditures, etc. It has to be real money. Now, I'll tell you, when the Medicaid director says, wait a second, I can't use IGT, you say, yes, but we cut your state match in half. Then they kind of calm down and say, well, I can do that. So you have to take the one with the other. Yes, we are eliminating some of the financing mechanisms, but we're cutting state match by 50% for some of the states, more than that for some of the states. Also, I'm a doc. Medicaid has bad outcomes. How do we improve that? One thing the MAC Act does, in each of these four categories, we will set up quality bonuses. So, by the way, I keep on using New York because they have such an active Medicaid program. New York apparently has really good initiatives in long-term care. With a good way to risk adjust payments to providers, they're really doing well. They are set up to win a quality bonus in the setting of long-term care. Now, that would be different from adults. My state has a high per capita incidence of HIV. I would love there to be a quality measure of what you do with an HIV patient's CD4 count over the course of a time period. If you really do something good for that AIDS patient, his CD4 count, her CD4 count, wow, you get a quality bonus. So in each category, there would be such as this. Next, right now, states, if you will, are relatively unincentivized to go after fraud and abuse. Think about it. You're a state with 50% FMAP. If you recover waste, fraud, and abuse, you give 50% of that recovery back to the feds. You can go after your road contractor who may be fraudulent, and you keep 100% of the money that you recover. you're actually incentivized to turn a blind eye to this place where you only get 50% recovery to focus on those where you get 100%. Because we're doing basically a per enrollee payment, you get this and you get no more, it is zero sum, the state retains all their fraud and abuse recovery, 100%. They also gain share, keep 100% of their savings from Medicaid. If they decrease readmissions among HIV-positive patients by improving their immunocompetence, and so by that program, they save their ADAP program or whatever, 10% of its cost, they don't give that back to the feds. They can use that to promote wellness in other areas of the Medicaid space. And so that is our MAC Act, which is, again, a bipartisan in parentage, which I think is fair to the states. There's other things I haven't gone over. I think it is superior to status quo and superior to block grant. And I thank you, Tom, for inviting me to speak.
It's our great pleasure. I don't know whether part of your promotion is you deserve a break today or just go for a Big Mac act in the next stage. But it's certainly a promising development on the Medicaid reform front, which is not what we've seen as much before, although there's earlier echoes of this to some degree with the per capita in the early 1990s. We want to keep on track. We're going to, next speaker is Christie Herrera, who's Vice President of Policy at the Foundation for Government Accountability. That's a Florida-based public policy research and advocacy organization. Many of you know of Christie's work previously as director of the Health and Human Service Task Force at the American Legislative Exchange Council, which is the National Association of State Legislators with at least one particular point of view as opposed to another one. There are some competitors in that field. She's going to talk about what has been developing in several states, and most notably in Florida as a different path for state-based Medicaid reform, and then some more recent developments in some of the states. Christie Herrera.
Sure. Well, thanks, Tom, and thanks to all of you and to AEI for hosting this event. Christie Herrera from the Foundation for Government Accountability. We are a new state-based think tank headquartered in Naples, Florida. In my, 10 minutes and change, I just want to share with you some of the experiences that Florida has had with its Medicaid waiver reform pilot project, which serves about 290,000 Floridians. That 290,000 is more than the entire Medicaid population in 17 states. So what I'll do is just talk about some of the key components in Florida. Then we'll talk about outcomes. At FGA, we found that Florida's reforms are both pro-patient and pro-taxpayer, and I'll tell you why. Very interestingly, Florida's reforms in November received a waiver from the Obama administration to continue its pilot project through 2014. So when you're looking at what can states do now and in the future, Florida might be a good example. And finally, as Tom said, I was previously at ALEC and kind of tracked Medicaid reform around the nation. We'll talk about what we can expect in 2013. So in 2005, Florida's Medicaid reform began. The legislature authorized the state to seek a waiver. CMS approved that waiver in a record 8 business days. So I guess it pays to have a Bush in the governor's seat and a Bush in the White House. The next year, 2 urban counties and then 3 rural counties decided to implement this reform. Just last year, the legislature passed another bill to take those reforms in those 5 counties statewide. What led to these changes? Well, in 2005, Florida was facing a number of issues that aren't much different than what states are facing today. Spending. Florida Medicaid spending was growing at double digits every year. If left unchecked, Florida Medicaid would consume 60% of the state's budget in just 10 years' time. 2, complexity. Florida was having a tough time managing its Medicaid program. They had 20 existing waivers. They had multiple delivery systems. 2/3 of their population was in traditional fee-for-service Medicaid. And finally, lack of choice and flexibility. There were no choices for Florida Medicaid patients. Basically, Medicaid was, as we always hear, it's a one-size-fits-all program where either you got it or you didn't. Luckily, though, in 5 counties in Florida, a monolithic Medicaid reform program is no longer a problem. Florida uses things that we hear about all the time: competition, innovation, incentives. These are things that create real, meaningful choice in Medicaid. So here's how it works. Florida Medicaid reform patients can choose from as few as 2 plans and as many as 10 competing Medicaid plans. The plans have to offer federally mandated Medicaid benefits, but the plans also offer customized benefit packages that not only combine optional Medicaid services, but also some services that aren't even covered by Medicaid, like over-the-counter drugs. Some plans even offer benefits to attract the sick, which is very different than what we're hearing in the national health reform debate. One plan in South Florida offers pregnant moms home-delivered meals after they give birth. Another plan is affiliated with the AIDS Healthcare Foundation. They give special benefits to people who are HIV positive. So patients have 30 days to pick a plan with the help of one of 31 full-time choice counselors that the state of Florida employs. The choice counselors are multilingual, they're culturally sensitive, they even perform field visits for Medicaid patients who might be homebound. Enhanced benefits. We want people to become healthier. In Florida, people on Medicaid reform can earn up to $125 a year for things like losing weight or quitting smoking. And finally, there are many working poor that are on Medicaid that have access to employer-sponsored insurance. In Florida's reform, that person can opt out of Medicaid entirely, take those Medicaid dollars, and then purchase coverage for their entire family. So that's basically the program. The outcomes have been pretty stellar. Here are some numbers that compare per person Medicaid spending for kids and families. You can see in the left-hand column, those are the numbers for Florida's 5 Medicaid reform counties. Per person costs are $400 lower than in the rest of Medicaid. That change alone in just those 5 counties means a savings of more than $73 million a year. The same goes with the aged and disabled. In Florida's Medicaid reform counties, per person costs are nearly $1,200 lower. So when you add up the savings from kids and families and savings from the aged and disabled, Florida is saving $118 million a year thanks to Medicaid reform. If and when these reforms are implemented statewide, Florida could realize nearly $1 billion a year in Medicaid spending. Here's actually a look at what would happen if Florida's Medicaid reforms were implemented in other states. And the darker the shading, the more the state would save. Every state would experience savings. 19 states would save at least $1 billion a year. And of course, New York, with their huge Medicaid program, would save over $13 billion a year. Of course, savings are just one part of the equation. We know that Medicaid has to deliver its promise of high-quality health care. Here's an apples-to-apples comparison of specialty care access for patients in Florida's Medicaid reform counties, for patients in other Florida Medicaid, and for people with health insurance privately nationwide. You can see that patients in Florida's Medicaid reform counties have equal or better access to specialists than everyone else in Florida Medicaid and even people with private insurance. Florida's Medicaid reforms are also improving patient health. Here's a look at some health outcomes in Florida's reform counties. For things like asthma management, diabetes care, mental health treatment, Florida's Medicaid reform patients outperform all other Medicaid patients in Florida and nationwide. For all of the health outcomes that are measured, not just diabetes care or asthma management or mental health treatment, for all of the health outcomes that are measured, Florida's Medicaid reform outperforms the national average more than half of the time. So is there room for improvement? Yes, but also patients are steadily improving their health every time these numbers are tracked. So we know that Florida's Medicaid reform is pro-taxpayer, and on average, it's making patients happier and healthier. But more importantly, I think people in Florida's Medicaid reform are becoming more empowered healthcare consumers, thanks to the power of choice and competition. We often ask in the public policy world if Medicaid patients really have the knowledge and the support to make their own healthcare choices. Well, in Florida's Medicaid reform plan, 71% of Medicaid patients are actively picking their own plan. Choice and competition also mean better benefits. Now Medicaid plans are marketing themselves to beneficiaries, not to state workers in Tallahassee. There are at least 2 and as many as 11 plans to choose from. Many of these plans are offering benefits to special needs and high-risk populations, and thanks to the power of choice and competition, 65% of Florida Medicaid plans don't even require a copay. Finally, what we found is that patients are responding to incentives for healthy behavior. Florida's Medicaid reform has been around since 2006. Since that time, Medicaid reform patients there have earned nearly $50 million in enhanced benefit rewards for healthy living. So I mentioned earlier that Florida has this reform in 5 pilot counties, and they're looking to expand the reform statewide. Last year, the legislature passed a bill that would not only expand Florida's Medicaid reform statewide, but it would also impose increased Medicaid cost sharing, that portion of which was rejected by CMS. However, CMS is still considering the statewide expansion. It would phase in 11 new Medicaid service regions. It would require previously exempt populations like dual eligibles to enroll. The requests and the negotiations are ongoing. We don't know how exactly it's going to turn out, but we do know that it will probably exceed the previous record of 8 business days. So that is what reform looks like in Florida. Here's a look at where states are with the now optional decision to expand Medicaid. All of the states are in red are either refusing the expansion or are leaning that way. All of the states in green are either going to accept the expansion or are leaning that way. Florida has already rejected the Medicaid expansion, along with South Carolina, Mississippi, Louisiana, Texas, and Wisconsin. Interestingly, when you look at the group of 5 or 6 states that have already rejected Medicaid, you'll see that most of them were very early and vocal opponents of setting up a state-run exchange. The most interesting thing, I think, of this map is the gray states. There are more than half the states, 26 states, who have yet to make a decision on whether or not to expand Medicaid. Finally, I want to talk about some states to watch next year. First of all, Illinois. Illinois is a Democratic state that had to make big cuts to their Medicaid program, over $1.6 billion in cuts just this year alone. Interestingly, Governor Quinn also knowingly flouted maintenance of effort requirements when he imposed a new eligibility verification system in Illinois Medicaid program. So when you talk about what states are ripe for reform next year, this is one of them. Louisiana, another state to watch, they are pursuing Florida-like Medicaid reforms, but without a waiver. They actually did it through a state plan amendment. So we talk about how tough and difficult the waiver process is. Louisiana has found a way around it. Washington State last year passed a bipartisan bill with not one no vote to basically implement Rhode Island-style capped allotments in their Medicaid program. The state submitted a waiver, negotiations dragged on, and in February, Governor Gregoire decided to pull her waiver request. Again, another state that is ripe for reform next year. New Hampshire, right now, one of only 3 states with absolutely no Medicaid managed care. So it's New Hampshire, Alaska, and Wyoming. But New Hampshire this year will start to implement Medicaid managed care with, so far, bipartisan support. And finally, Kansas. They have a new governor and a lieutenant governor who is also a physician taking up CanCare. It's Kansas's own Medicaid reform waiver that would not only impose Medicaid managed care statewide, but also allow an HSA option for Medicaid enrollees. It's not clear how exactly Kansas is going to turn out, although we would imagine that negotiations with Kathleen Sebelius and her home state to be very interesting. So that's basically a 10-minute run through Medicaid reform. Would be happy to take any questions.
Thank you very much, Christie. That was quite economical, and we've got a lot of food for thought, but we're not serving lunch today. So we're going to have some thoughts before you move on to lunch. Let's kind of see if we can squeeze in a couple of questions before everyone has to leave. If you could raise your hand, identify yourself, keep the commentary down to a couple of sentences, and actually ask a question, it'd be very much appreciated. Anybody out there? Ooh, there we go. Right behind you. Oh, go, okay.
Okay, thanks. Thanks to everyone. Appreciate the time. My name's Alex Benowith. I'm with United Spinal Association. Interested, Secretary Alexander, with your comments about Rhode Island, how successful they are. I do appreciate, obviously, the cost and the need at the state level, of course, but Rhode Island is a small state, small population, and that system, that what they have in Rhode Island, doesn't always apply or cannot easily be applied to other states. Would appreciate your comments on that. Thanks.
Yeah, I would respectfully disagree with you. Rhode Island has one of the highest elderly populations in the country. It also has one of the poorest economies in the country. So from that, and it's also a democratic state. So from that perspective, if it's worked in a small state, you can try it, or in another state like Washington State, who the governor, Democratic governor, looked at Rhode Island's model, liked it, the capped allotment, and wanted to be able to try it. Unfortunately, her own administration, her own party rejected it. But I would disagree with you because the waiver itself, it's the framework. It's not whether it's a large state or a small state. It's the actual framework of flexibility from all of the onerous federal rules. And states need that flexibility. So if a small state was able to achieve success for its elder population, its disabled population, and especially those high-cost populations, then a larger state could achieve that same success. It has nothing to do with the size.
And I would actually agree. I mean, Florida's pilot program was 300,000 people, and that's probably the population of Rhode Island. It's much harder to achieve real reform in a small state, especially private sector competition, because when you have a small population, it's hard to attract insurers that want to come in and play and offer plans. So, we talk a lot about access to care in rural areas. Small states have those problems as well. I think that makes what Secretary Alexander has done in Rhode Island all the more impressive.
Very good. I think one question back there, then we'll go to Dave next.
Brian Blaze from House Oversight and Government Reform Committee, formerly of the Heritage Foundation, and I have two quick questions. The first one is, as a first best solution for healthy people, wouldn't it be better to just get rid of the Medicaid program and replace it with a refundable tax credit? I know that is the Heritage solution. Second question, it seems like while the court decision is, on one hand, it's good, it gives states flexibility. It sets up what could be the worst possible outcome for federal taxpayers if you have states expanding or reducing Medicaid eligibility to 100% of the federal poverty level, and then people above that getting the federal subsidies. So is that where we think we're going in equilibrium? Any thoughts on that?
I always hesitate to take a question from a guy who's written a dissertation on Medicaid, but that's okay. Heritage Foundation, I saw, just reviewed what they just put out regarding Medicaid reform, and Tom can correct me, but they actually talk about using a per enrollee payment or per capita cap for the pediatric and adult population, block granting that for the blind and disabled in long-term care. So I think that even though Heritage is very much into the refundable credits, for the Medicaid population, they'd still keep that structure. And frankly, I'm pleased that for two of their populations, they have considered using the per capita cap.
I'll just add that we do have to run some numbers on this. We'd like to think that everyone will be able to buy very expensive private insurance, which costs a lot more than the inadequate Medicaid coverage they're currently getting. There's a bit of a balancing act. You can make things more efficient and more economical, but if you just do it as a straight swap, you're going to be vastly expanding your budget for the Medicaid population based upon what is currently allotted for many of those beneficiaries. More work needs to be done. Question?
Let me just pipe
Okay.
in. Also, there is a question, if states do not choose to set up an exchange, it may very well be that the credits that you're describing do not accrue. the actual language of the Affordable Care Act limits the credits to state-run exchanges. IRS has tried to expand it to federally run exchanges, but if states are worried about that, if they don't set up the exchange, then I think there's going to be litigation. I think it's likely to be successful, that there will, and if there's a President Romney, he can change the IRS interpretation. But the statute itself does not contemplate or call for subsidies on federally run exchanges.
That IRS interpretation might take a couple of days more than day one to change, though, since it's a final rule. But that's under some dispute at the moment. Yeah, sure.
One thing to stress about our model, by the way, it's strictly financing. I think of health insurance, if you will, which Medicaid is, as financing, administration, and patient care. Okay, three parts. Now, our financing mechanism could work with a Florida model, with an Indiana HSA model. If Vermont wants to go to a single payer, it could work with that. All it is a financing model, so theoretically it could also be used with premium support for Medicaid patients to go into the private sector. We're agnostic as to what the states do in the spirit of federalism.
Okay, I think we've got about another 5 minutes or so. Question back there.
David Hoagberg with Investors Business Daily. Congressman Cassidy, I think your ideas here have a lot of merit. But one thing that kind of stood out to me was this notion of a quality bonus, which has been thrown up in a number of reform plans, and there's always the concern that providers will kind of try to game the system by getting the population that's somewhat more healthy. And I think the CBO has looked at a number of these programs in Medicare and found them that they don't really work. I'm just wondering if you have some concerns about that, and is there anything also in your Medicaid program that would leave the dollars more with the recipient, so that if the recipient improved their health, they would get to keep any of the savings? I'll just leave it at that.
Okay. As regards the first thing, one of the things I didn't discuss, but we do risk adjust payments. And so if your state has a sicker population, then it is going to be risk adjusted, and we base that upon the current Medicare, the MA plans. The CMS risk adjust payments to the MA providers. And as I gather, Florida risk adjusts payments to their based on health status. So this risk adjustment is understood. Inherent in risk adjustment is that you know when somebody's doing better. Now, believe me, everything in our proposal has been tried in states. Alan Levine, one of the architects, is a good friend of mine. He was in Louisiana for a time. And he said, yes, we are looking at these managed care organizations, looking at how they respond in terms of hemoglobin A1C for diabetics. Now, if Florida can do that, by golly, I sure hope that the federal government can do it. And I will note that in PPACA, they certainly think they can do it because they have several measures where they risk adjust and otherwise monitor quality of care. As regards the dollar following the recipient, again, we're strictly a financing mechanism. So if a state like Florida wants to do a kind of payback to patients for whatever they want to do, in the spirit of federalism, here's your per capita cap, your per enrollee payment, you do it. We are strictly financing. The administration we leave to the states.
Very good. I want to make sure I'm not squelching one last inquiry or line of dissent. We said we would finish at noontime. Did I see a twitch back there of a question about to arise? I guess not. It was only my mirage. Please thank our excellent panel today for a thorough discussion.